Let's remind you about what happened a little bit earlier on at the Senzo Meyiwa murder trial. Magistrate Vivienne Cronje conceded that accused number 2 in the murder trial, Bongani Ntanzi's detention, was irregular. This was after revelations that Ntanzi was detained for 8 days without going to court. Cronje, however, says that there was nothing she could do about it at the time, as it was beyond her control. Mpumelelo Zikalala is a legal analyst, and he's standing by to help us make sense of developments as we saw them and heard them today. Thank you very much, sir, for your time this afternoon. Let's revisit that cross-examination of the witness earlier.
Now, after telling you this, that he had been kept in an unlawful detention, what did you do as a magistrate to release him?
Dit is nie binne my magte om hom vry te laat nie, en ek het die aangeleentheid ten opsigte van hierdie punt aan die senior landros gerapporteer nadat die konfessie afgeneem is.
It was not within my powers to release him, and that this particular aspect, I mentioned it, or I reported it to the senior magistrate upon the completion of taking down the confession.
Yes, I agree. It was not within your powers to release the accused, but it was within your powers to stop and to say, I cannot proceed taking down a statement from a person who has been or who is in unlawful detention before me. Am I correct?
Dit was nie op daai stadium vir my geoorloof om dit te doen nie, aangesien ek slegs 'n eensydige weergawe het van sy kant af van hoe hy voor my gebring is en ek nie al die feite gehad het.
Okay. It was not within my authority for me to do that or to release him at that stage, and I only had this one-sided version.
Mpumelelo Zikalala, if we follow the timeline as we heard it in court, Bongani Ntanzi was arrested on the 8th of June 2020. Only on the 24th of June did he make the alleged confession statement. He appeared in court only on the in October rather of 2020. And so how will this assist the court in coming to a determination whether indeed the statement was made under duress, because essentially that's what this trial within a trial is about?
Good afternoon to you and also to your viewers. Well, you look at the whole facts or the whole sequence of events and the evidence that's been provided to you, and you say to yourself as a presiding officer, what are the chances that a person who has been in jail for so long would be motivated, and I say that in inverted commas, to say whatever the investigating officer that brought him to that particular court are telling him to say in order for him to be released. I think it was only in appropriate times when a person would spend so much time inside a jail cell without appearing to court. Our position is very clear in terms of the 48 hours, which are mandatory, by the way. They are non-negotiable. A person has to appear within 48 hours, unless when they appear in front of the presiding officer, who is a magistrate, by the way, they're supposed to make all the particular inquiry and take the appropriate action. You have the power as the presiding officer to then say to the IOs, sit here while I wait, and I'll even talk to my chief magistrate as to the type of breaking of the law that has taken place in order for you to take action which is going to be favorable to the accused in this case. In fact, it's not even a favor in which you are doing. You are simply making sure that you are enforcing his rights. So definitely it's going to have a huge impact in even supporting what the defense is saying, in terms of saying that this particular statement was not given in a friendly manner. It was undue to arrest that has taken place. It is not voluntary. It may have been that in terms of the tick-box exercise in whatever forms that needed to be filled in. However, if you look at the sequence of events around the taking in of that particular statement, they don't speak to the same thing.
And then you have the issue of the alleged legal representative that both the magistrate and the interpreter who's taken to the stand today say was in the room, and this is something that the accused indeed confirmed that it was his legal representative. Let's revisit that moment.
I remember the presiding officer had a conversation with the gentleman. I mentioned earlier that he was dressed in a suit.
Could you hear what the nature of the conversation was?
Well, as far as I can recall, I think she was asking him who he was.
Yes.
And the gentleman said that he was the legal representative of the suspect at the time. And this was confirmed by the suspect himself after he was asked by the presiding officer.
Mpumelelo Zikalala, you've got two witnesses that confirm that indeed this Mr. or the said Mr. Mjiyaku, the alleged legal representative, was in the room when this alleged confession statement was made. It was confirmed by the accused. You have the defense saying that in fact their client does not even know this Mr. Mjiyaku. He was not represented. What will assist the court in coming to a determination on whether indeed he was represented or not?
The first prize would be finding Mr. Mjiyaku himself, and if he's brought to court, he'll then be able to testify, were you really there? Did you pretend or did you represent the accused? If so, why is the accused saying something which is totally different from what you understood your instructions to be at that time? Secondly would be, in the executing of his or her duties as a magistrate, you'd want to get those pieces of information. Who is that particular individual? Which firm do they come from? And a bit of investigation from the side of the IO and the state. You can go to Legal Practice Act website and be able to type in that particular name, and something ought to pop up if that is true, a legal rep that has been registered with the LPC. So it's one of those instances in which maybe it's going to come up at a later stage within either cross-examination, or himself would be called to come in and testify and give evidence to say, were you really there on the day? The most important thing would be to say, as a person who's representing the interest of the accused, what did you do in order to assist the magistrate in executing your duties? Was there particular information which was provided to you, to the magistrate? Is there anything that you've signed on the day? If there are any registers when you come into the court, do you have that particular process or that particular evidence to prove that indeed on that day you were there? But what that does, it does not take away the duties of the magistrate as per Section 217 of the Criminal Procedure Act. Regardless of whether the person is represented or not, the magistrate still has a duty to make sure that whatever information it is going to receive is given to her freely and voluntarily. There's no element of duress which are taking place, but most importantly, follow the proper form and all the information that should be included in that form to ensure that the evidence can be able to suffice in court on the next days.
Okay. And then you had the defense advocate on behalf of accused number 2, Bongani Ntanzi, being concerned about the interpretation. This in relation to the witness that has concluded her cross-examination, as we're expecting a new witness come 2 p.m. Let's revisit that moment.
The content of this wording, or what is contained in your certificate, has it been explained to the deponent? Did you explain it to the deponent before you attached your signature?
No, my lord.
Do you have the reason why you did not explain it to him?
I do not.
So was it important for you to explain it? Or was it an omission on your part to explain it?
No, my lord, because I have never had to explain the contents of the certificate to the deponent or anybody for that matter.
From your observation, when you appended your signature on the certificate, did it come to your attention or did it come to your mind as to whether the deponent might be curious as to what you are signing?
If I may ask, my lord, is it only with regards to the certificate?
In regards to the certificate?
No, my lord.
The testimony of the interpreter was quite short and sweet, with many of the defense advocates not really cross-examining her. How helpful was the testimony for the court to come to a conclusion? Because the defense advocate for accused number 2 was concerned about interpretation.
Which rightfully so, because where they are trying to drive to is, yes, you have a confession in your hands, which is written in a language in which the accused number 2 is not their mother tongue. So did you really explain to them what does it mean? So if the interpretation for meaning is the context that must be understood, and if I say yes or no to whatever content which is available in that affidavit, I must understand exactly what am I meaning when that particular document has been written. If that loss in translation has been taken place, If there's no explanation as to why you are signing a particular certificate, it means that you're not giving informed consent. Your consent is missing in terms of its gravity and its full extent in which it ought to apply. So it was crucial for this witness to be brought in, so to sort of lament the fact that you knew exactly what you were consenting to, you knew exactly the gravity of the consequences which were then needed to follow. If you do not know what the consent is about, and you lack knowledge as to what the consequences are going to be, then it can't be said that you have given informed consent.
Raised the issue of what is the role or the job of an interpreter, and he wanted a specific piece of law to be read out, and towards the tail end of the cross-examination then he referred to a specific case law, and so it'll be interesting to see the interpretation on the part of the court. But thank you very much for your time this afternoon. Mpumelelo Zikalala is a legal analyst.